Rob is an adjunct professor of law and public administration at George Mason's School of Law and in the GMU Department of Public and International Affairs. And he is the Associate Director of Regulatory Studies and Government Accountability at the Mercatus Center at George Mason University. As the Associate Director of Regulatory Studies and Government Accountability, Rob manages research for a wide network of economic, legal, and public policy scholars and oversees the work of the Mercatus Masters Fellows involved with regulatory studies and government accountability. Rob Raffety is a graduate of West Virginia Wesleyan University, or West Virginia Wesleyan College, isn't it, Rob?
Still college.
Still college, okay, and has a JD MPA joint degree from Syracuse University. If you will, join me in welcoming Rob Raffety. Immediately to Rob's left, our other panelist in the first panel is the Honorable Hal Stratton, a former Attorney General for the state of New Mexico and chairman of the Consumer Product Safety Commission, and an adjunct professor at George Mason University School of Law, where he has created and teaches a course on state attorneys general, multi-state litigation and regulation, and he is a senior counsel in Brownstein, Hyatt, Farber and Schreck's Albuquerque office. From 2002 to 2006, he was chairman of the U.S. Consumer Product Safety Commission. He's a member of the New Mexico, Colorado, Oklahoma, Texas, and District of Columbia bars, so I hope he's getting CLE credit for all of those today. And he is admitted to practice before the United States Supreme Court, as well as a number of federal and appellate district courts. Please join me in welcoming Attorney General Stratton. Without further ado, I'll turn the program over to Rob Raffety.
Thank you, Jim. Again, it's an honor to be here. Thank you for assembling this distinguished panel. It's my privilege to be on it. As Jim mentioned, this is a panel of former state attorneys general, although I'm the only member of the panel who does not have that distinguished status. Nevertheless, by virtue of working for Mr. Stratton when he was the chair of the Consumer Product Safety Commission, getting to know him in that capacity as his legal counsel, subsequently had the opportunity to work with him in the development of a course at George Mason University School of Law on the subject of state attorneys general, and I've inherited those duties, so to speak, and I continue to teach that course, and I'm very grateful for that opportunity. Just as I get in here, my task in setting up our discussion here today is to provide you with a quick overview of the Office of State Attorneys General. And I think the first thing I'd like to do is ask if anyone in the audience has ever worked for a state AG. I assume we're all, or most of us would be lawyers, but I don't see any. Okay, that's good. That means anything I say you will take as true. How many of you maybe work for members who were former state attorneys general? Oh, who is that, sir? Senator Cornyn from Texas, former state attorney general from Texas. Very interesting and good to note, and that will lead us into, in a few minutes, a discussion of how this role has evolved over time and is in some sense now a great entree into future political careers for many folks who are state attorneys general. But I'll take us back to begin with here, just looking at a broad sense of this office, what it is, and how its duties and powers have evolved over time. I'll start off by saying that the position of Attorney General is firmly rooted in over 700 years of Anglo-American history. Since at least the mid-13th century, we've had this specially designated counselor to the King of England, and that role has historically been to represent the interests of the king in that country's courts of law. In the same fashion that America inherited much of its legal framework from Great Britain, the state attorneys general is part of that tradition. Does the name Lawrence Del Broke ring a bell? Probably not, unless you're a Jeopardy champion. But this is the first written evidence of the king's attorney, again, mid-13th century, responsible for initiating actions to recover rents. sounds like the king's landlord, investigating homicides to hear and determine what pertain to the crown, and to take action to protect state property and interests. So again, the origins of the state attorneys general are rooted in English law, and it develops significantly over time, which leads me to another trivia question. Can anybody identify this man? First Attorney General of the Virginia colony. Any trivia buffs in the audience? Maybe the former Attorney General. This is Richard Lee. Richard Lee, who was the first, has the privilege of being the first Attorney General for the colony of Virginia. There he is. This is 1643. The roles of colonial AGs vary significantly from colony to colony. They were appointees under the office of Attorney General of Great Britain, and they were working in the Americas to represent the interests of the crown in America. But what we see here is quite varied responsibilities from colony to colony. And although much of them, again, are rooted in English tradition, given the diversity of our country, the AGs from state to state are often influenced by other cultures and customs and legal traditions unique to their respective states. So, for example, in Pennsylvania, the AG was interpreting and inheriting British legal traditions, but also adopting certain traditions from Sweden and Netherlands and the Delaware Indian customs, as well as Quakers. And again, imagining the diversity of our nation at that time, we can see the evolution of the AGs as evolving in a unique way with respect to each particular state. And we also notice over time that although the AGs are here to represent the interests of the king in the colony, they in some sense begin to act as a bit of a political counterbalance to the governors of the colonies, and exercising a little bit of discretion and independence in that respect. Post-American Revolution, the AGs are retained in each of the respective 13 American states in the United States, and over subsequent years of expansion, the office is established in the constitutions of 44 of 50 states. And today, all 50 states and our territories, including and also the Washington D.C., have an office of the state, or have an office of Attorney General. That leads us to a very important question. Just as the duties and roles of the AG evolved very uniquely in each colony, they continue to evolve uniquely in each state. And so one important thing to ask is, how do AGs come to power? How are they selected? Well, much of this, not surprisingly, depends on the respective state. The vast majority of states, 43, AGs are elected in a popular election. But 5 states, Alaska, Hawaii, New Hampshire, New Jersey, and Wyoming, the AGs are appointed by the governors. Anybody here from one of those states, or for a member from one of those states? The qualifications for office are not uniform from state to state either. And you might be interested in knowing, in case you have aspirations of running for office someday, in 25 jurisdictions, 25 states, no minimum age requirement to run for Attorney General. And in a handful of states, there are no bar admission requirements. You don't even have to be a lawyer to be the chief legal officer for your state. Quite interesting, and again, it shows that the evolution of the state AG is very different from state to state. So when as I talk here a little bit, go in more detail about the roles and duties and authorities of state AGs, it's very important to take all this with a grain of salt, noting that it really is unique. Each state has different powers and duties and responsibilities. We're going to run through a list of the powers, again, broadly speaking, of state attorneys general as they exist today. And the primary role of the state AG is to be the chief legal officer of the state, to provide legal advice to the governor and state agencies to ensure the legality of state government action. Another duty and power of state AGs, and a very important one, as we will come to learn later in the panel, is the ability to control litigation on behalf of the state. And in this sense, most but not all states, AGs have a great deal of discretion and prerogative and authority to control litigation at the trial and appellate levels, and including multi-state litigation activities. So when we talk a little later with our former AGs, we'll certainly get into issues of alleged activism and state attorneys who are going beyond perhaps what their constitutional bounds might be. A third important, very important role of the state AGs is to issue opinions. I always thought it would be nice to just get to write my opinion and send it out, and that people would care about what I have to say. But state AGs are, do have some authority and speak with some power, although when they issue written legal advice in this manner, it's typically not binding on the courts, usually given some level of deference. And again, no two states do it the same. So the manner in which a state attorney general issues an opinion, or the basis for that, whether it's being upon request or just based on the attorneys general's prerogative, that can vary significantly from state to state, and opinions can carry great weight or no weight depending on the state from which they come. Another very important role that we've seen emerge over the past 50 years, primarily the second half of the 20th century, is the role of the AG as a public advocate, an educator. This is really distinct from the traditional legal functions of the office, but we see it with increasing frequency, and in some sense, we can again hear from our panelists on this. Many AGs view that as one of their primary roles, to educate the public, make them aware of various issues ranging from child support enforcement, consumer protection, antitrust actions, rate and utility regulations, and even victims' rights work. So to the extent that the state AG's office has evolved from simply a legal enforcer, an advisor, to a public advocate, we see some interesting trends and consequences from that. I will also note that some states, but not many, the state attorneys general are in charge, are sort of the top cop of the state, and are responsible for oversight of criminal prosecutions by the district attorneys. Another important power is the investigative authority. AG's offices have teams of investigators that can be tasked at the AG's discretion to investigate government misconduct, malfeasance, criminal activity. Again, a fairly broad scope of authority, and we see a lot of AGs using these investigators to uncover various acts of interest to the AG. And finally, a really important role, again, has emerged in the latter 20th century, is the AG as a policymaker. Again, not an advisor, not someone who simply is there to interpret and enforce laws, but rather someone who, by virtue of holding a statewide office, is engaged in a political process, trying to influence the legislative process, advocating for the adoption of various laws and rules and statutes. And to this extent, we see AGs sometimes issuing an opinions in coordination with their role as policymaker on issues such as election reform, public corruption, open government. In this sense, the AG may be in a mini bully pulpit, not quite as powerful as the chief executive for the state, but arguably in some cases perhaps more powerful. And again, when we hear some of the lessons and stories from our panels, I'm sure this will come to full light. A couple more slides. The powers and duties flow for AGs from three primary areas: common law, state constitutions, and state statutory law. Under the common law, again, this is a very broad origin of AG authority to represent, defend, and enforce the legal interests of state government. And there's a landmark case, which is Florida v. Shevin. I'll read a portion of it just to give you an idea of just how broadly the courts have interpreted the AG's common law authority. The attorneys general of our states have enjoyed a significant degree of autonomy. Their duties and powers typically are not exhaustively defined by either constitution or statute, but include all those exercised at common law. There is and has been no doubt that the legislature may deprive the attorneys general of specific powers, but in the absence of such legislative action, he typically may exercise all such authority as the public interest requires. Very broad and sweeping authorities recognized by the courts with respect to the common law. As I mentioned, 44 of the 50 states give broad authority and recognition of their state AGs in their state constitutions. Some states have a little more prescriptive provisions by statute. But what we really see here is an office that has, by law, very sweeping and broad authorities. That's the important message for you to take away, because with those authorities comes a great deal of power and influence. I think one more. So with respect to the conduct of litigation, again, this is the role of the Attorney General in bringing legal actions on behalf of the state and its people. Very important authority, and it flows from a variety of areas. And again, because of the broad mandates in Constitution, for example, the state of Illinois, AG shall be the legal officer of the state and shall have the duties and powers that may be prescribed by law. It seems very, one sentence in the Constitution that creates the office and really gives it almost limitless authority in the eyes of some. AGs also have what we call the common law prerogative, and under parens patriae, which is Latin for, we were debating this earlier, and I'm not sure the exact Latin phrase. Is anyone taking Latin here? Parens patriae, I think more or less equates to the authority of the state to bring action on behalf of its people to protect the interests of their health, comfort, and welfare. Very broad common law authority. And then what we're here to talk about today, really, at least to lead us and kick off our discussion, and I'll be turning it over to Professor Stratton in a moment, and that is this emergence of express statutory enforcement provisions at the federal level, which we see only really in the past 40, 50 years, but emerging and now re-emerging here in Congress, which should be of great interest to you and your members. So that was a very broad, sweeping overview of the Office of State Attorneys General. I'll now turn it over to Professor Stratton so he can talk about the authorities, the enforcement authorities that have emerged here of late with respect to federal law.
Thank you, Rob. And yeah, that's what we're here to, I think that's what's of interest to you all here is why are you interested in what the Attorneys General do? And when we started our course over at George Mason, and really prior to that time, as I was on the stump talking about the new Consumer Product Safety Improvement Act, which how many folks here had involvement in that a couple of years ago? Senator Cornyn, I guess. And well, I would regularly say, the state attorneys general really don't have enforcement powers when it comes to federal statutes. But here's a new one, the Consumer Product Safety Improvement Act. And then our other co-professor, who's a former executive director of NAG, said, maybe you should read the book here and see if you're correct. So I read the book, and then I revised my course file to show that there are a number of statutes that you all here, the Congress, has given the states to enforce. And this is a list that I know of right here. There may be others, but this is the NAG book's comprehensive list of those statutes. And as you can see, there's a number of them.
What is NAG, Professor?
National Association of Attorneys General. So I'm sorry, I assume that everybody has heard of that, and obviously you haven't. So, so anyway, that's if this is a powers and duties book. If you ever are interested in what the AGs actually do, this is kind of the definitive Bible here, and you can get it from NAG, from the National AGs Association here, and I commend it to you if you ever need something. We use it in our course. In fact, this is our text for our course. So It's a good book. Our co-professor actually edited it, and she'll be here a little bit later. So anyway, here's the list. We're talking about telemarketing, consumer fraud and abuse, home ownership and energy protection, credit repair organizations, Children Online Privacy Act, Nutrition Labeling and Education Act, Telephone Consumer Protection Act, Truth and Mileage Act. That's rolling back the odometers. And then finally, the Consumer Product Safety Improvement Act. And I can tell you, and I'll be interested to hear from the former attorneys general from the other states, but I didn't enforce any of these when I was the Attorney General in New Mexico. They never came to my attention. And some of them admittedly have been passed since that time. But we didn't know anything about federal product safety law, and we didn't know anything about a lot of other things. But what we did know is our own statutes, and so we proceeded to enforce our own statutes. So it's interesting, and I have come up with, I've looked for cases where the state AGs are actually using these acts. But as you'll see at the end, I think there's another avenue, probably, that is causing them not to use them as much. What I thought I'd do first is kind of show you how this works. Since you've passed this sweeping law at the federal level regarding product safety and given the state attorneys general, each of them, you know, I guess it's the 50 states. I don't know. I assume the territories, D.C., and the others have the same powers to enforce these acts. Let's look at see real quickly how that scheme plays out. In federal product safety law, there are there we go. There are several agencies that actually do consumer product safety and do recalls. It's the CPSC. The EPA is another recall agency. In fact, I found at the CPSC we most often overlapped with the EPA as far as our duties were concerned. The USDA and the FDA, and typically they don't overlap there. The FDA's jurisdiction is pretty clear. The Coast Guard. Does anybody here know what products the Coast Guard regulates? The U.S. Coast Guard, they regulate boats. So if you ever have a boat anywhere and you have a recall on a boat, it won't be the CPSC, it will be the U.S. Coast Guard doing the recall. And then NHTSA, the National Highway Traffic Safety Administration, and of course that does cars. Am I there? Oh, okay. So now we'll go to the Consumer Product Safety Commission. We're going to carve out one of those agencies to see how the CPSIA works, because the Consumer Product Safety Improvement Act gives the AGs the power to enforce the statutes that are administered by the Consumer Product Safety Commission. And these are the statutes. The primary one is the Consumer Product Safety Act. That's sort of the organic act for the agency. Federal Hazardous Substances Act, that's the one that regulates lead, in case you've been watching that over the last couple of years. Flammable Fabrics Act regulates flammability of furniture and other products. Poison Prevention Packaging Act is the act that mandates the child-resistant caps on prescription drugs and on other consumer products. That's actually the CPSC, not the FDA. The Children's Gasoline Burn Prevention Act, that was an act that was passed just a little bit before the CPSIA back in 2007, which mandated the standards for gasoline cans in the country. And then the Virginia Graham Baker Pool and Spa Safety Act, that's a brand new one, and some money was actually appropriated with that one regarding the safety of mainly of swimming pools and drains. The drains are the important thing because that's where you get entrapment, and spas. And then finally, the Refrigerator Safety Act. Now, we never enforced this either because we didn't have to. This was passed years ago to make sure that refrigerators, when I was a kid, you're always told don't go into a refrigerator in the vacant lot because you won't be able to get yourself out and you'll suffocate. And this act has really, frankly, eliminated that problem. Now you have to be able to open the refrigerator door from the inside. So that's the act that does that. So those are the acts that now the CPSC, as well as the state attorneys general, can administer. So how does the system really work? This is, in one slide, the way the federal regulatory safety system works. You have the agency promulgates and helps adopt product safety standards. And for every one product safety standard that the CPSC has promulgated, there are about 10 other voluntary standards that are out there that the industry uses and that are developed through voluntary standards development organizations. Product recalls, everybody knows about those, so that's compliance. So the agency implements recalls when a product is not safe, speaking generally. Education, we all thought education was a very important thing in product safety, so we tried to put as much resources and time in that as we possibly could. And then research, and anybody want to give me a guess about what the research budget is as a percentage of the CPSC budget over there? Like less than 0.5% of the budget. So there's literally no research going on. I say no, I mean garage doors a little bit, garage door openers, some things like that. But generally there's no budget for federal research on product safety, at least at the Consumer Product Safety Commission. So what happened? Well, under the Consumer Product Safety Improvement Act of 2008, these powers were given to all these state AGs that Rob has described to enforce the federal acts. And I'm not going to go through them at length, but most of them were couched in the form of an injunction, and the state AG can go to federal court and get an injunction against these particular acts. Just looking at them briefly, sale of products that violate the CPSC safety standards. So previously the AGs couldn't do that. Now if you got a product on the market that violates the safety standard in your state, then the AG can go to federal court and enjoin the sale of that particular product. Enjoin the sale of recall products, you wouldn't think that would happen much, but from time to time it does happen. Even though products are recalled, people are still out there selling them. Enjoin the sale of banned hazardous substances, that would be lead. You've maybe heard of cadmium recently, antimony, some of these other things that are hazardous substances. The state AG can do that. And on and on and on into the next slide. So basically, the state AGs can go out and enforce pretty much any of these acts, but they do it through an injunction in federal court. They have to go to federal court, and it has to be through the injunctive process. So the way the AG has to proceed to do this, that's set out in the statute. Has to go through, as I indicated, appropriate injunctive relief, has to be in federal district court. You have to provide notice to the CPSC 30 days ahead of time before you proceed. The commission may intervene and be heard, which is sort of interesting because the commission can't intervene and take the case over. If the state AG starts a case and the CPSC comes in later, then they are an intervenor, and they have the rights of an intervenor and not the rights of the actual party plaintiff. And of course, the AGs cannot bring a suit if the government is already bringing a suit. So there's no duplicative opportunity there for the state AGs to be involved. If the CPSC's doing it and doing their job, then it's a federal action and the state AGs would not be involved. That's the, relatively speaking, unimportant powers that the AGs have. The really important power that was given to the AGs under the CPSIA is the ability to enjoin the sale of substantial product hazards. Those are all the products that you hear that are being recalled. When you hear of a product out there that is on the market and is being recalled, it's because it constitutes under the federal law a substantial product hazard. And I've given the definition here for those of you who really want to get serious about it. And maybe the definition is important for one reason, and that is at the CPSC or in the state AG's office, there is no real formula for what a substantial product hazard is. If the chairman at the CPSC or the state AG gets up in the morning and thinks maybe the product over here is not as safe as it ought to be, they can then proceed to try to make a showing that that particular product is a substantial product hazard. And if they do, then the court will find that it should be removed from the market. Here the AG would proceed to enjoin the sale, but that would eventually involve a recall as well. Here's the procedure specifically. You identify the product. There has to be immediate action necessary for the AG to go ahead. Otherwise, they got to submit it to the CPSC. Well, what circumstance where you've decided that a product should be recalled because it has a substantial product hazard to the public, is it not immediate? I mean, you want to get it off the market the next day. So that's not a particularly high standard or a high hurdle to get over. Notice is provided to the CPSC, email's enough. File a complaint in the U.S. District Court, and then once again, the CPSC can intervene, and they're there as an intervener, not as the petitioner or respondent, but as an intervener. So that's the way the federal law works. Pretty powerful stuff. There was a lot more. There were a lot more powers given to AGs in the initial draft of the legislation, and this was compromised down a bit. So you can imagine what it might have been had the original bill passed. So far, I've seen very little activity by the state AGs under this act, and I don't know of much under the federal act. We're going to hear from two other formerly active attorneys general here and what they did in their states, but we just didn't see much of it when I was there, and we haven't seen any in the last 2 years. It's now been 2 years since the AGs have had these powers. 1.5 years, actually, August of 2007. How long is that? That's 1, 2, it's been 2.5 years that they've had the powers. And I don't know of anybody that's used any of these statutes so far and that's acted under any of these statutes. And so the question is why? I mean, the Congress has given them the power. We've seen all of the acts that they have the powers under. And I don't know why on the other statutes, but some things came to mind regarding the CPSIA. Number one, there's a lack of expertise in a lot of these areas in the state AG's office. In our office, consumer product safety was not an issue. It was being handled by the federal government. We had our hands full with the budget that we had and all the other business consumer actions that were going on, consumer fraud and misrepresentation. So we pretty much paid attention to that and not to other federal issues. Occasionally, states will get in on a multi-state settlement when it comes to product safety or a product recall or a penalty, but it was pretty rare, and typically when we did that, we were just throwing our hat in the ring and saying, send us the money. I've heard from a number of attorneys general recently, and they happen to be in town right now at the NAG conference, and I've heard from a number of them that lack of funds is a real problem here. I talked to our Attorney General in New Mexico, and he's about to get a 25% cut in his budget, which would be unprecedented, and the legislature is trying to make him take account for some funds that they've collected in penalty matters and use that instead of using the appropriations process. So you can imagine he's not thinking about going out right now and instituting actions to recall baby cribs or something like that. He's too busy with his hands full doing what he does under state law and what his state mandates are, representing state government, criminal white-collar crime, those kind of things. So he's got his hands full. So I think that's one of the reasons. State consumer statutes, I think, can maybe be used more efficiently than some of the federal statutes. And I find it difficult to come up with any scenario under at least our consumer statute in New Mexico, and I'm gonna flip over and talk about a few of these in a minute, but that you couldn't go out and do what you needed to do, even when it comes to product safety. If you have a consumer fraud and misrepresentation statute, and you have somebody that is selling cribs in your state that are killing babies because of a product defect, I think that product was sold under fraud and misrepresentation. So I think they can use those statutes, and I think they don't have to use the federal statutes. Under the federal statutes, the states do not get any compensation. There's no way they can go after a penalty. Excuse me a minute. We all have colds up here, so keep your distance. There's no way to make a recovery like treble damages, say, in a typical state consumer statute under the federal law. So if you're a state AG, don't put all this effort in these kind of things, you're going to go under the law that gives you the best advantage. In the NAG book, just as a kind of to conclude, there are 4 different types of consumer statutes out there. And frankly, I think all of them probably work in this area. I don't know if they work in the telemarketing and consumer fraud and abuse area. I'm sure they would. I can't think of any federal act here where you couldn't take your state consumer statute and do exactly what you wanted to do. This once again comes out of the NAG book, and I think the characterizations are, excuse me, general, but I believe those statutes can be used for pretty much anything that they need to do. I don't know why this next slide's in here, but it's interesting. These are the other types of consumer statutes under state law that a lot of states have. So as you can see, there's a whole lot of different statutes that the states have that somewhat duplicate the federal law. So if you're a state AG and you got a state law that gives you treble damages and attorney's fees and penalties and all of this kind of thing, you're obviously going to use that. Plus you get to go to state court. And I think most state attorney generals would rather be in state court, depending upon, you know, all things being equal. It just depends. It depends on which judge you get, frankly. But I think you, well, I mean, as in every case there is. Well, they obviously have some thoughts on that. So finally, just recently, an example of what my theory is here kind of came up, or at least came to my attention, and that is in Vermont, the state attorney general went after the Dollar Tree stores for penalties because of a recall of jewelry that had cadmium. And he did not use the federal acts to do that. He used the Vermont Consumer Fraud Act, which we have cited there at the end. And now the recall had already occurred, so I'm assuming that Dollar Tree, I didn't check this out, I should have, but I'm assuming Dollar Tree had already recalled the product. And then he, the AG of Vermont, went after Dollar Tree for a penalty under their state Consumer Fraud Act and was successful in getting a settlement. You're always going to get a settlement. There's very few. I can't remember in anybody's memory at the CPSC was there ever a litigated penalty case. That's not actually true. There's a couple fireworks in the early 2000s penalties that were litigated where the fireworks companies all lost. And so there hasn't really been a mandatory recall at the CPSC since the early 2000s because they're all voluntary. If you go to a company and you say you need to recall this, very few of them are going to fight with you about it. And in this case, this resulted in a penalty as well. So that's an example of what I think happened. So what difference does that make to you all making policy here? Well, I don't know. I mean, it may make some difference. It may not make some difference. It's sort of how you feel about it. And I guess I would suggest that putting the state AGs into an enforcement role regarding federal statutes has had minimal effect on the enforcement of those statutes in the past. And it seems to be having minimal effect with the CPSIA. And if you start putting it in health care bills or Consumer Financial Protection Acts or other things like that, I'm not sure what help you can predict. I mean, maybe it's a good thing to do and it looks good and it makes the member feel good that they've given more powers to state AGs to enforce important laws. But I can't say that we've found in our experience that it's really had much real effect. So with that, I'll conclude, and I want to thank you all for coming today and for your interest in this subject matter because it's important to all of our constituencies out there. Thank you.
Thank you. Let's thank our first panel. Because we are on the clock for CLE, we're going to move right on to the second panel. Feel free to help yourself to pastry or coffee in the back of the room, but we're going to continue with the course. And we're going to move right on to the Honorable Peggy Lautenschlager. Ms. Lautenschlager is a former Attorney General from the state of Wisconsin and a former United States Attorney for the Western District of Wisconsin and a representative to the Wisconsin Assembly. She's taught in various roles at Ripon College, the University of Wisconsin Law School, and the University of Wisconsin Oshkosh, and currently practices law at Bauer & Bach, LLC. As the Attorney General for the state of Wisconsin, she supervised the Wisconsin Department of Justice and the 550 employees in its 5 offices and divisions. She earned her JD from the University of Wisconsin in 1980 and her Bachelor of Arts in History and Mathematics from Lake Forest College in 1977. Please join me in welcoming Peg Lautenschlager. Our final panelist today is probably familiar to many of you who live here in the D.C. area, Northern Virginia. Jerry Kilgore is the former Attorney General of the Commonwealth of Virginia and currently the Senior Vice President for Government Relations at McGuire Woods Consulting in Richmond. Mr. Kilgore is assisted in a variety of corporate and association clients with multi-state projects and matters before state attorneys general around the country, and his work has touched on a wide range of issues including antitrust, federal-state relations, and trade industry regulations. As Virginia's Attorney General from 2002 to 2005, Mr. Kilgore served on the Executive Committee for the National Association of Attorneys General. He also served as an Assistant U.S. Attorney for the Western District of Virginia and Assistant Commonwealth's Attorney for Scott County, Virginia. Mr. Kilgore received his J.D. from the Marshall Wythe School of Law at the College of William and Mary and his Bachelor of Arts from the University of Virginia's College at Wise in 1983. Welcome, Attorney General Kilgore. We'll do this panel just slightly different. We're going to make this one a little more of a discussion, and Professor Stratton, feel free to jump in, you too, Professor Raffety. But we'll start with you, Ms. Lautenschlager. In your view, what generally is the proper role and function of the state attorney general, particularly in terms of federalism and dealing with things like antitrust, Medicaid, environmental enforcement, and so forth?
Okay. Hi. First of all, thank you for the opportunity to be here. It's a pleasure. What do I just pull us a little closer to? Okay. Okey-doke. There. Is that better? Okay. I'm Peg Lautenschlager. It's a pleasure to be here with you, and I'd like to thank the college for or university for inviting us to be here. I think it's a topic that merits some discussion. To set things out very bluntly in the beginning, I would be the Democrat and the activist Attorney General. Jerry would not. So you will see. Yes, you were actually, and I would make that argument a lot. Anyway,
so activism is completely nonpartisan. It's not the issue.
Activism is nonpartisan. It's just on what you're activist about. I think that's the difference. But that being said, I also, though ironically, represented a state where the laws were probably some of the most restrictive, as you'll read in the book that was touted earlier. In terms of powers of the Attorney General, Wisconsin has very, very broad powers given to its chief executive, the governor. But it does not give the Attorney General much power at all. In fact, our common law specifically says that the Florida case that was cited by Mr. Raffety earlier and others do not apply in Wisconsin, that there is no parents patriae authority, that there, unless specifically authorized by either the Constitution, state statute, the governor, or one house of our state legislature, the Attorney General may not act except in defense of cases against the state, which is a statutory authorization too. So for me, as the so-called activist AG, my challenges were not only to figure out, my issues weren't only dealing with kind of what areas did we think that it was appropriate for a state attorney general to intervene, but more importantly, if we did think it appropriate, whether or not we could find some sort of authority to intervene given our limited jurisdiction and authority. So, so for me, the topic of discussion is a little bit different than it would be for other state AGs. I'm kind of the antithesis of, say, the New York Attorney General, who has such broad powers in that regard. That being said, at least in my sense, I have always viewed the job of a public lawyer, particularly one who is in some way tasked in representing the people of the United States or the people of a particular state, to be one where you do things that are for the common good, that are done in the interests of justice and in the best interests of the people of the state or the nation. As a result of that, I have personally at least always felt as though issues like antitrust, Medicare, Medicaid, the environmental enforcement we talked about, securities frauds, consumer protection, and other areas were ones where oftentimes state attorneys general act as an important safety net when there is no federal action. I think in part that philosophy that I hold comes not just from my political values and kind of political philosophy, but I think also comes from my experience having worked in local, state, and federal government as a prosecutor. I went from being a state elected district attorney, a local prosecutor, where our major charge was prosecuting criminal cases, and you'd walk into court and rock and roll not knowing which of 3 felonies might be tried that day. Usually not murders, but never murders, but perhaps a couple burglaries and something drug delivery, to and yet being charged as a local prosecutor with enforcement of certain civil laws, and you just never had the time to do those, and you never had the ability to do those because the needs of your county were focused more on the criminal enforcement end of things. I then went to become a U.S. attorney. I was U.S. attorney during the Clinton administration, where the administration itself very proactively looked at the use of civil enforcement laws in ways that I think are different from in previous administrations, both Democrats and Republicans. They expanded things like Medicare fraud, giving more money to the states for Medicaid fraud enforcement, a lot of environmental law enforcement, a lot of treble damages, False Claims Act kind of stuff, and the like, and tended to have the luxury of being able to do a fair number of those cases at the federal level. But of course, at the federal level, you had the requirements of federal court, which I think can fairly be characterized as being far greater and far more meticulous when it comes to presenting a case, a lot slower, that sort of thing. And so very oftentimes, U.S. attorneys' offices wouldn't bother with certain cases, either thresholds, it was below a threshold that was set in terms of lost amounts, things like that. And so there's this kind of bunch of cases in the middle that don't get dealt with locally for various reasons, don't get dealt with at the state level, and then there are sometimes opportunities for state attorneys general to act. And I think those broad categories of cases have come onto the laps of state AGs everywhere, and it's, I think, interesting to see. Some AGs have been more, quote, activist, others have not. Some have been activist in certain areas, but not in other areas. But those cases do kind of get squarely put in front of you, and you become sort of the reviewer of last resort. And I think Hal is absolutely right. One tends to lean toward looking at these matters from a state perspective and a state court perspective. But I think as we move on, we can talk about some of the factors that go into those decisions.
Mr. Kilgore, same question. What's the proper role and function of the state attorney general?
I think it's evolved over time, and I think it all started with the tobacco lawsuits, and that sort of sprung this office from relative obscurity to national headlines just overnight. And I think we've seen that all of us are attending the National Association of Aspiring Governors meeting, or AG's meeting this week, and everyone, I mean, the lobbyists are there in full force. It's become the place to go to represent clients. There's a lot of us represent clients before state attorneys general, and I would say 20 years ago it was probably the dead zone for lobbyists. That a few came back that were former AGs, but that's about it. And now everyone's there. Every major company has a representative at the National Association meetings, because state AGs are exercising this great power over the boardrooms, over business decisions almost every day. And Peg and I will get into that later on in the questioning activism in what area. But you see state AGs active in the financial services arena, particularly with the Cuomo v. Clearinghouse Supreme Court ruling last year that gives states the power to regulate national banks as long as they're not overly interfering with the federal rules. And you're seeing state AGs exercise that power pretty quickly. Not just New York, West Virginia has sued some national banks over marketing practices. You have pension fund investigations that mainly started in New York, but you see a lot of the larger states with the ability to investigate, and it's not just Democrat attorney generals. You have some Republican AGs that are out being very active protecting their consumers, and it goes by office. I think we all will point out that the larger offices have the ability to get in and do these very complex investigations. For the smaller offices, you have seen this growing trend of outside counsel showing up on your doorstep to pitch a matter for a certain fee. They're also over at the convention to pitch matters to, we'll take this suit for contingency for your state, sue for your pension fund, there's a variety of ways to sort of gain the state's jurisdiction, if you will, and to allow those suits. But in the past year, we've seen suits against major companies, Wells Fargo, H&R Block, the Oppenheimer funds, all under the theory of protecting consumers or protecting state pension funds. You also see activism, if you will, in the technology arena with data breaches. The most recent one, TJ Maxx company had had a major data breach, and the AGs went in to deal with that issue. And then it seems like daily there's a new prescription drug suit by state AGs based upon consumer issues. The consumer statutes in these states, very broad. You can basically act. There was never anything that prevented me as a Virginia AG from acting. The law allowed me to act. Usually I didn't act because of my views, and my view was call the business first, talk them through the problems, the complaints you were getting, and see if they can fix it, act later. But other AGs don't have that view. They act quickly and file the action. You see it in a lot of areas. I submit that we mentioned antitrust. I think that one moves so much slower than anything else. You're slow to get involved in the antitrust arena. We led, when I was AG in Virginia, on a couple of antitrust national suits, but you usually work in tandem with the U.S. Department of Justice on those issues. They have all the resources. Rarely do states go it alone on these antitrust suits unless it's sort of an intrastate merger. Hospitals come to mind where you bring the suit on your own to deal with the hospital merger. But generally the bigger businesses, the national businesses, you work with other states and other offices that have great antitrust expertise, whether it's Texas, Florida, New York, or California, or Iowa. They all have great antitrust shops that are ready to help you. And then in the environmental enforcement, that tended to be, for me at least, intrastate as opposed to interstate. We worked alone on those issues. And the problem for all of us up here was what did your state agency really want to do in these arenas? I mean, but for the true consumer protection cases, you had a client that you had to at least talk with before you brought an environmental action, or before you brought take securities, for example, or your pension fund. You had to go talk with your pension fund managers to see if there was really a problem, if Virginia was losing money because of those issues, or other states. So it really, the proper role would be to protect your your consumers, but just, I would submit, not overprotect, not go out and protect just to get the headlines, but to make sure there's a real loss, there's a real problem out there, and I took the view that you give the businesses at least a chance to answer and come in and make their pitch to you on why or how they could change to make it better.
Since both of you were U.S. district attorneys, you've sort of seen things from both sides. You've seen it from the federal side and from the state side. Is there good cooperation when you're back in the Attorney General's office and you're working with federal counterparts? Or is that something that there's more friction than help?
Well, it depends on who's in office and the personalities, I would say, of the U.S. Attorney for your districts and the Attorney General. And it depends a lot on whether either have further political ambition, just being blunt here, and who wants the press out of the particular situation. We worked a lot together on Medicaid fraud issues. We assigned prosecutors to the U.S. Attorney's Office that became special assistant U.S. attorneys on Medicaid fraud issues. We had Medicaid fraud investigators that worked inside the U.S. Attorney's Office to put together those cases. On the bigger fraud cases, we didn't always work in tandem together on those investigations, and particularly in Virginia, where so much of the power for prosecuting frontline criminal matters rests with the local prosecutor and not the state attorney general. When I was AG, we slowly took over some of those responsibilities with the opposition from the local prosecutors in technology crimes and identity theft, some of the arenas that we would claim or prove to the legislature that local prosecutors just won't have the expertise, and we do have the expertise in those arenas.
I can't emphasize enough Jerry's correctness in saying it depends on the personalities of the actors. And one of the interesting things, whether it's the relationship between a governor and a state attorney general or U.S. attorneys and a state attorney general, I think there's sort of a joke among U.S. attorneys that sometimes it's better when they're of opposite parties in terms of getting together than when they're of like parties. And we always thought we should have support groups for those of us who were, quote, stuck with either a governor or U.S. attorneys of a like party so that we could all commiserate together. I think Jerry's absolutely right in that there are a number of factors that go into whether or not a particular attorney general wants to be out on Front Street and the amount of cooperation which exists. One of the things we had talked about in preparing for this earlier was the influence of money on these kinds of things. If the federal government gives states monies to, say, have prosecutors who work hand in glove with U.S. attorneys' offices on issues of, say, Medicare and Medicaid fraud, we will use that federal money in order to hire those kinds of folks. Sometimes those relationships are good, sometimes they are bad, sometimes they are sort of relationships where two sets of prosecutors coexist and maybe compare notes on cases, but the envisioned cooperative thing doesn't work. There are other areas where it has worked marvelously well. I can think of a few specific examples, which I think are always nice for all of you. One in the environmental area, where in Wisconsin we had a Burlington Northern train come off a faultily maintained track, and there was a civil action regarding the railroad not maintaining the track. It happened in northwest Wisconsin, near Lake Superior, in a town near a town called Superior, Wisconsin. And in that case, our State Department of Natural Resources and the EPA in part worked together, but in the end it became kind of a race to the courthouse door to see whether or not the U.S. Attorney's Office, which is where I was at the time, or whether or not it was the State AG's office that would first file suit. And in large part, again, that was driven by money, because the issue became who could get what damages and who would have control of those damages. It also happened to be on properties that were tribal lands, so then we ended up with this additional factor having to do with tribes. That's a session for a different day. But that's kind of a good example of where everything kind of breaks down and things don't happen correctly. On the other hand, I look at it, and I started prosecuting in 1985 when, tragically, there are too many of you here who probably didn't even know you were going to law school at the time. But you know, historically, there have been the Organized Crime and Drug Enforcement Task Force, inappropriately named OSADEF, which I never did quite understand, but you all get to do what you want with your acronyms, I guess. But in the OSADEF area, there tended to be relationships that were sometimes very positive and sometimes negative. For example, when I was U.S. Attorney in the Western District of Wisconsin, we viewed many of the small cadre of DEA agents we had, frankly, as what we would call cowboys. And they were kind of off doing their own thing, always pushing the amendment on the big, the Fourth and Fifth Amendment and the big ones that stand in the door when it comes to justice. And they were always sort of kind of doing the end run and, well, can't you get this in or whatever. On the other hand, we had a phenomenal working relationship with the Division of Criminal Investigation, which was run out of our State Attorney's General office, as we did with the FBI and ATF and other federal agencies involved in the OSADEF task force. So in part that was driven by personality, but in part it was driven by kind of the cultures of the agencies as well, I think, or at least the local cultures of the agencies. So things like that enter into it as well. In the securities actions, I had the interesting experience of dealing with a securities fraud case in a company out of Wisconsin, and as Wisconsin Attorney General had somewhat limited jurisdiction on dealing with it. It was called the Strong Fund. And on the other hand, at the then Attorney General Spitzer jumped on this, and then we ended up with the two of us, state versus state, in I don't know, one has terms for it, let's just say a controversial relationship, which ended up being okay in the end. But where I felt as though a state attorney general, I had an obligation to represent the people of Wisconsin and not worry about what the New York Attorney General thought. And so so you have those kinds of relationships, which sometimes can be very good and sometimes can be very bad. One thing I would say when it comes to these sorts of things is that, and I think, Jerry, for the most part, this isn't always true because there are no absolutes when it comes to these descriptions, but I think state attorneys general, while we have acted increasingly in an increasingly partisan vein in the last decade or two, it's sort of like the kids growing up in a household where you beat up your brother and sister until the neighbor kid comes over and comes and beats your brother up, and then suddenly the family pride takes over. And I think it's fair to say that state attorneys general have had that kind of attitude, I think less so now than before, but on many issues, particularly involving federalism. Do not call list comes to mind, where several states, including Wisconsin, passed laws that were more strict than the federal law. The 10th Circuit looked at that issue. Judge Henry issued a ruling. I haven't followed it since, but where there was the issue of whether or not state laws that were more strict than the federal law were enforceable. And when we had those cases, I did an amicus for the state attorneys general on behalf of, I think, was that Oklahoma, I think, that brought that case. But we had both Democrats and Republicans standing up and fighting, saying, hey, you guys can't be overturning our state laws. We have the right to do whatever on these. And so in those sorts of areas, I think you find a lot of commonality of interest, and you find a lot of defense of the rights of states to continue taking these actions, whether they're viewed as good or bad.
Now, I would say any time federal law attempts to preempt state law, you're going to have almost 40, probably 45 AGs sign a letter to say do not preempt state law. That's the one time we do work together. Those are easy letters to sign because you're standing up for your state law, and you may not agree with the New York law on the issue, or the California law, or the Texas law, but you agree with your law, and you're there to enforce your law, and you'll sign the letter.
Well, and That's been an interesting evolution too, because historically it was the so-called Democratic AGs who tended to be for federal enforcement and things in the 60s and whatever, and you've seen sort of a turnaround of that in some fashion. But one of my favorite examples was Bill Lockyer was Attorney General in California, which has a very specific labeling law, and I noticed that Hal had the labeling law as one of the federal laws here, but there was this notion that the federal law should preempt the California labeling law, and we had a press conference at a NAG conference probably in about 2006 where you saw Democrats and Republicans alike all standing up saying, you know, our states deserve the right to do this. I mean, you know, in Wisconsin, you do not want an out-of-state brat inappropriately labeled, or, you know, or the wrong cheese curd labeled as a cheese curd when it really doesn't have cheese products in it, you know, and so, you know, we were all there. We were all there with Lockyer on that, and it really didn't go to whether or not people thought that labeling law was correct or not. Coca-Cola was I think the biggest company fighting against it, wanting the uniform labeling law. But it was amazing how many people who tend to be traditionally conservative kind of threw out the Coca-Cola concerns and whatever else in order to say, wait, you know, our states have a right to do this. So,
What effect does it have on federalism when the federal government says, here's a law, Attorney General, we would like for you to enforce this for us? Is that a good thing?
Well, if it comes with money, it is. The Medicaid fraud is a great example. 75-25 funding by the federal government. We then share in the take, if you will. We get our share at the state level, and the feds get theirs. But it gave me, as Attorney General, the ability to quadruple that staff in the Medicaid fraud unit, open Medicaid fraud centers all over the Commonwealth. But we didn't do that in other arenas where we are given the absolute ability to enforce because the money wasn't there. We had other priorities at the state level.
I don't think there's an Attorney General's office in the country that hasn't faced budget cuts. Maybe North Dakota, I think. Yeah, I think they said something about they actually are doing okay as a state financially. But you know, during my tenure as Attorney General, which was 2003 to 2006, we had almost 20% of our staff was lost, and a lot of funds we had, which afforded us opportunities to do additional things, were also lost. So you were always kind of looking around desperately for money. The Medicaid fraud example, and I know there had been Medicaid, Medicare task force in the past, those are huge examples, I think, of how whether administrations at the state or federal level are liberal or conservative or somewhere in between, or however you characterize them, D or R or whatever, you have a commonality of interest or maybe a little bit different perspective. I think the Democrats in those laws tend to look more toward things like quality of care cases and actions that go against healthcare providers themselves and the corporations, whereas I think the Republican administrations have looked more at the individual bad actors, but or corporate bad actors for that matter. But nonetheless, I think everybody has really worked hard in those areas and has taken federal monies and I think used them to the benefit of people in the states. What's interesting about that area as well is that I know during the last Bush administration, Congress passed laws which gave states incentives to duplicate the False Claims Act, the Federal False Claims Act. I was one of those states which did not have that. And when we get into those subjects of when do you go to federal court versus state court, in our Medicare area, when we had the quality of care cases or the cases against a medical provider and not employees thereof or individual providers, we would always look to ways in which to get in the federal courthouse door so that we could take advantage of the Federal False Claims Act and the treble damages provisions, which we did not have in Wisconsin.
Professor Stratton, I'd like to bring you into the conversation just quickly here. As head of the CPSC, you were working on the federal side. Did you receive good cooperation from attorneys general in what you were trying to do?
I'm trying to I'm trying to think if I had a conversation with a state attorney general while I was at the CPSC, and other than going to the NAG conferences, et cetera, I don't think that we did, because you recall this consumer products. Well, you don't recall, but the Consumer Product Safety Improvement Act came in after I left the CPSC, so we didn't have the state AG enforcements. But I'll talk about one thing. I'm going to plead guilty to Peg's accusation that some of us conservatives changed our tune a little bit on preemption, because I was one of those people. And when I was at the state level, there's kind of a knee-jerk reaction when you're a state attorney general on preemption. I mean, get out of here, federal government. Sometimes if the federal government wants you to do it, you do the exact opposite thing just to teach them a lesson. And not a very good attitude. And when I got to the Consumer Product Safety Commission, I learned about how important it was to have some uniformity in products and standards across the country. And in fact, even in this latest Consumer Product Safety Improvement Act, which is the most sweeping thing that's been done in that area in 30 years, they maintain the strong preemptive provision for federal product standards, just for that very reason. And in fact, in the CPSIA, the provision says if the state standard varies, whether it's lower or higher from the federal standard, it still is preempted. So they want a national standard everywhere. If you're going to sell something in California, you want to make it the same way you sell in all of the other states. So it struck me that that was not an unreasonable thing to have nationwide, and it's in the statute, so I had to enforce it regardless, and I didn't really have any say in it. But that was certainly one area where I plead guilty to looking at it and saying, maybe this is an area where we do need preemption, where we do need one federal standard. So there's that. I want to ask Peg a question, because you brought up something very interesting that I hadn't thought about. My state law as Attorney General allowed me to get into any suit or bring any action for the benefit of the public. So that's pretty broad. I think we'd all agree. So, and we had a very broad Unfair Practices Act. It sounds like Jerry's is the same in Virginia, pretty much. So that might color my view as to whether these federal statutes are really needed by the New Mexico Attorney General. I wonder in your case whether it might be more advantageous for you to have these than not.
Well, that was a topic of dispute. My predecessor as Attorney General, Jim Doyle, who currently serves as governor, when he was Attorney General, took the position that if there was a federal law authorizing a state Attorney General to act, that indeed the Attorney General could act regardless of the state constitution. Tommy Thompson, who was then governor of Wisconsin, said no. The Wisconsin Constitution says the state Attorney General may not take action unless requested to do so by the governor or one house of the legislature, and that indeed it was the Wisconsin Constitution which governed the powers and authority of the state Attorney General. Clearly, I think that the state constitutional limitations influence how the Attorney General acts when it comes to state court. But I think the interesting issue is, does that state constitution also limit the federal court participation of a state Attorney General? And then also when it comes to that, whether or not, if that state Attorney General goes into federal court, whether or not he or she can act on behalf of the people of the state of Wisconsin, or whether or not you have to have some other party as your, quote, client, unquote.
How'd you answer that question when you were
Well,
Attorney General?
needless to say, I was Attorney General, so I thought I had the power and authority. Jim Doyle changed his viewpoint on this when he became governor. As
Amazing how that
most
happens.
Attorneys General do. That's not like a partisan comment. That's a power comment, a power and authority comment. But that being said, it's still unresolved. In our current situation, I don't think you'll see that happening because the current incumbent is somebody who has been more in tune with Jerry's approach, actually way beyond Jerry's approach in terms of kind of the laissez-faire attitude toward enforcement of these kinds of laws. So I don't think that we'll see it coming up, but it is an unanswered question, Hal.
Jim, let me respond. I do have a response to your question. Let me finish that up, Jerry, and then I'll turn to you. But currently, since the CPSIA is in effect, my understanding is that the CPSC has not a task force, but they got somebody there that is liaisoning with the state AGs on a monthly basis. And so I think they're having, I first heard it was quarterly, recently I've heard it's monthly. So they are trying to coordinate, and I think that the big concern about this is that the cowboys, I'll use the term that Peg used, out there in the Attorney General world, we're going to take this out in their states and create new law that would be divergent from what the federal law was or what the other states' law was. That has not appeared to happen so far, and it appears that the state AGs are very interested in making sure that that the law works right, and from what we hear, they're having meetings and they are coordinating. So,
And I would just comment on Peg's, the governor's comment. Nothing, other than preemption, nothing brings AGs together more than a governor attacking another AG over powers and duties. Peg's had it, I've had it, the governor of your state telling you, you work for them, you're their counsel, and we all remind them we are not your counsel, we are elected ourselves, we are here for the people, and just because we don't agree with you, doesn't mean we're not working for the people.
Well, in fact, I had an interesting situation because when I was, and there are a couple AGs where they do have that model, several of them appointed by the governor. New Jersey's a good example. But it's interesting because I had a conversation with my predecessor, then the newly elected governor, as to whether or not I would like to have a position on his, quote, cabinet, which included the secretaries of our state departments. But that the caveat would be, as while I would be able to participate in the policy meetings of the cabinet, that and where voices could ostensibly be heard in that meeting, that once one were to come out of that meeting, we would all act in unison based on the governor's final decision. And I had a long conversation after, and then he concluded by saying, I don't know that I would have done that had I been when I was Attorney General. And but you know, it gets to an interesting question in terms of powers and duties, Hal, which is sort of that notion of, as a state elected official, can you really make that determination to sort of cede your power to a governor in that fashion? And you know, I don't know, it's out there, but I would think citizens of the state could have, could have cause to consider options for recourse on something like that.
Yeah, I mean, you've heard about this from these guys. Just to make the record clear, I had a Republican governor that I served with. I was limited to one term, served one term, and we never got along on anything. And I was never invited to any cabinet meetings. And he, well, he had a view that you get elected governor and you think you're running things, and you think everything comes out of the governor's office, and then you say you go out and you decide to sole source a contract, and it violates the state statute. What do? Well, I mean, you got one choice. You got to enforce the state. I mean, you enforce the rule of law. That was always my view. But I just wanted to echo the thoughts. It seems odd that that AGs and governors of both parties who serve in the same party would fight more than the ones that are of opposite parties. But it actually is the case out there, because I think the governor in your party always expects you to do what he wants you to do.
I think they think they can get by with something, whereas if you have an AG from the opposite party who's probably an aspiring governor, you're always kind of careful and walking on eggshells in terms of, figuring out how you do things, whereas if it's a person of a like party, it's sort of, oh, well, Peg's not going to make a complaint about that sort of thing, and I think that's very true. I don't know.
Oh, it is. I worked with a Democrat governor, and I think one of my framed cartoons from that era was Governor Warner's big concerns, and they had it like on the security level, code red, code orange, and I was code orange for him, that he was always worried about what the speaker or I had to say about something from a legal perspective. I think it was easier to work with the Democrat governor, and in Virginia at least, when you've had AG and governor of the same party, it's been very, very much friction. We're waiting to see if that's going to happen in this new era.
I'd like to turn to the term activism. You've talked about that a little bit, but I'd like to focus on it specifically. Is activism or aggressive enforcement anti-business or pro-consumer? Let's start with Mr. Kilgore on this one.
Well, I think it can be both. I think it depends on what you're being active about. We see AGs active in a lot of areas, from the traditional criminal justice side, which most, in my view, see as good activism, where I worked on domestic violence issues, victim issues, identity theft, gangs, things that got educated the public and got the AG's office out leading on certain issues. Other arenas where you have true bad actors, we didn't hesitate to get involved, where people were being defrauded, things of that nature. We'd wait until we got 10 or so complaints about a company before we'd launch an investigation. But the fishing expeditions that go on now from certain AG's offices, those I see over the top, where you don't even know what your company's being investigated about. You can ask staff, what are we being investigated about? They won't tell you, and you eventually have to get a meeting with the AG or the chief deputy just to find out what are you looking for, where are we in trouble with your office. And my problem has an AG, my problem has a former AG, and now in private practice is, I think every AG ought to ask the question, am I doing my job? Am I doing what my state statute intends for me to do? Or am I trying to develop new public policy from the Office of Attorney General without going through the legislative process?
I don't necessarily disagree with Jerry's principles. I think how I would apply them is somewhat different than where Jerry is. But I think there are two things I'd just like to add to the mix on the discussion. And one is that there are certain areas where sometimes aggressive enforcement is greeted in the broader business community with thanks. Because when you have the corporate bad actor who is doing things that give that actor an unfair advantage over those who are following the law, I think you find no more intense support than from those who are following the law, and I think we all kind of agree on that sort of thing. I know one area right now where we've been looking a lot at it, and state attorneys general of both parties have been looking, is in what is kind of broadly and not necessarily accurately described as misclassification of workers. There is some disagreement over whether or not state attorneys general should be looking at independent contractor laws in quite the way that they are in some cases, but in other cases I think there is just uniform agreement that or paying workers under the table or doing those sorts of things is just plain wrong and just plain gives an unfair advantage in competition to those competitors willing to violate the law. Right now there is, for example, litigation being contemplated looking at FedEx, and for those of you who followed that issue, you know that there's been an issue as to whether or not FedEx drivers are independent contractors or not. There are those who say they have their own truck. It's like allowing somebody to create their own business, etc. The flip side of the argument is when FedEx tells you you have to wear FedEx socks while you're in your independent business, is it really an independent business? And obviously, there are a ton of tax dollars at stake here, as well as benefits for workers. The flip side, though, is we had another situation where a custodial company was not hiring but contracting with people who were custodians, mostly immigrants from other countries, who were given the opportunity to rent floor space in a large office buildings, which they got to clean at night, and were considered independent business people because they were, they told them this is what you have to buy for your cleaning equipment and the like, and this is the square footage you're renting from us for the right to clean, and you are an independent business person, and welcome to America. I think probably all of us agree that that is not an independent contractor situation. So there are things like that where I think all of us sort of look at, when the law is used to go after what is clearly a violation of the law, but in where it is leveling the playing field for business, for the businesses following the law, that it's a good thing. I think some of us disagree as to whether or not that playing field's being leveled or whether or not the government's going too far in terms of its intervention.
Professor Stratton, how did you strike that balance?
Well, I'll tell you how I'll strike it. The first thing that comes to mind as I listen to my colleagues here is that there are a number of attorneys general who will threaten to bring an action even though they know they don't have a valid case under their law, just to get a settlement or affect behavior. And that's not something I believe in. I don't think any of us believe in that up here, but I'm telling you that happens, and it happens more often than it ought to out there. And it happened even in my day, back in the old, what are now the old days of the Attorney General world. We had, it was easy for us because we had this idea that we had to enforce the rule of law based upon our statutes, our Constitution, and the common law. And so we tried not to go outside of that. If we had a situation where a consumer bought a product and they didn't like the price and they wanted to turn it back in, that wasn't something that was any of our business. Or if somebody went out and made a loan that they ended up paying too much interest on, in their opinion. In New Mexico, we have no usury law, so they would come in and say, well, I think I'm paying too much interest on this. That's not something I think you get involved in, and that's not enforcing the rule of law. The law is there is no interest rate. On the other hand, and we had, I believe it's still the largest consumer action in the state of New Mexico when I was there. We had the 10th largest Ford dealership who was routinely engaging in criminal acts when it came to their customers. They would lock people in closets until they agreed to buy a car. They would take your car and appraise it and drive it off, and when you came back and said, well, I've changed my mind, they'd say, well, we've already sold your car. They would, you've seen the vacation that really happens out there. They would throw keys on the roof until you bought a car. They would do these kind of things. They would take consignments in to sell cars and then sell it for more than they told their consignor and keep the difference in the price. And that, we thought all of that was illegal. And we thought that they should be taken down. And as we were taking them down, we then had 6 employees come in and give us affidavits about the prostitution and cocaine ring that was going on inside the dealership. Now, maybe this is an easy case, but it took a year and a half. This was the 10th largest Ford dealership in the country, selling a lot of cars. Half of the advertising on TV in Albuquerque was paid for by this particular dealership. And, the television stations were a bit, are we going to cover this? We're going to lose half our revenue if we cover this. But that's the difference to me. This isn't somebody going in and getting a bad deal on a car or having buyer's remorse or wanting the help of the Attorney General. This is criminal activity. And as a matter of fact, that we got settlements out of them, we got a penalty out of them, and we sent 3 people to jail over those kind of activities, and it eventually resulted, and this isn't something a Republican Attorney General necessarily is proud of, in the dealership shutting down over all this because of the bad publicity. Now, when it came to the other dealers in town, they knew this had to happen. They knew what was going on. They knew something needed to be done, and they knew it was kind of an open sore in the industry. But so we did it, and they kind of had They were lukewarm about how they felt about the enforcement, because although they knew it had to be done, it also affected car sales in Albuquerque for a year for everybody. But in that situation, it's just something that you got to bite the bullet, and maybe the dealerships, the other dealerships should have done something earlier themselves to help us resolve this matter. That's kind of the way I feel about it.
If I could just piggyback on that too, Hal. You know, it's interesting, but you know, we glibly talk up here about the power of governors and the power governors think they have. Prosecutors have a tremendous amount of power, and I think you all know that, whether they're federal prosecutors or state prosecutors. And I think it's even more greatly affected or impacts when it comes to criminal law area than the civil law area. But, you know, and there are those who we may view who have been prosecutors who are bad actors. I have my successor as a local district attorney ended up in federal prison for misuse of his power. But it's interesting because I think whether something that transcends political philosophy lines is a notion that, number one, for most of us, I think, number one, that if you're going to threaten litigation, you better be ready to litigate, whether it's a criminal case or a civil case. You don't say to somebody, you know, you might get charged with murder, when indeed there's no way you can make a murder case. You don't say to somebody, you know, we may do consumer fraud action against you when you don't have the goods available. I think most of us think that's just wrong. But the other two rules I would add to that are, number one, as a government prosecutor, I think you have a particular obligation for transparency because you are serving the public. I know I had what is somewhat unusual, but policy that in civil litigation, we made certain, even if we entered into a settlement or a consent decree in a case, that it would never be not public, that it would always be a public agreement, which many corporations didn't like because they wanted to settle it, pay their money, and go home and not have anything in the public record. But we always felt as though we were going to bring the case. It goes back to Hal saying you don't bring it unless you have enough there to go through with the action. But I think the transparency thing is a real issue. And the other thing is sort of the doing it for publicity. And this is one of those kind of which came first, chicken or egg questions, just like, you know, did the lobbyist from a certain company give your legislator money because your legislator is beholden to him, or is it that your legislator feels that way and that person happens to agree with your legislator's actions? And likewise, in the publicity area when it comes to prosecutions, whether they be civil or criminal, you know, you don't not do publicity, and in part there's maybe a public obligation to do it and be forthright with what your office is doing, but the flip side is are you doing the case to get the publicity, which I think we all agree is probably wrong, or are you getting the publicity because you were going to do the case? So.
Let me mention one other thing, Jim, on that, because I think the tobacco cases, which is the biggest and the most famous within the AG world, is an interesting study on this. This was after my time. And there's no way I would have ever dreamed up the legal theory by which the attorney generals went after the tobacco companies. It just wasn't something, and it still is untested, by the way. I mean, I don't know that it's ever been tried. So that was a very activist move. But I will say this, and I'd be interested to hear how, both these folks dealt with tobacco. I didn't, so I'd like to hear how they feel about it. Once the settlement was made, let's say I'm sitting in New Mexico, I don't believe in the legal theory by which the state attorney generals are going after the tobacco companies. Then the tobacco companies settle. They say, all right, states, we're going to give you billions of dollars to settle this matter. What do you do? Well, I think you got to get in on a settlement. I mean, I think you have a duty to your state, even though you don't particularly agree with that theory, or maybe it's not that you don't agree with it, maybe it's you don't understand it, but you still have to go in and represent your state and get what you can get. Otherwise, I don't think you can sue an attorney general for malpractice, but whatever the equivalent would be, impeachment, I guess, or something like that. What do you guys think about that?
I would say that I came in right after the settlement, and Virginia and North Carolina did not participate in the lawsuits going forward, but they absolutely participated in that settlement. And I grew up in the tobacco growing region of the state, grew up on a tobacco farm, and certainly not a legal theory I was enamored with. But, you know, when you get hundreds of millions of dollars to the state, you sort of have to enforce it. We we enforced the laws. We had, I bet, in those early days, I'm sure 20% of my meetings involved tobacco issues, whether at the state level, meeting with non-participating manufacturers or participating manufacturers, or at the national AGs meetings. We were all concerned with the enforcement of the agreement, making sure that we were enforcing and passing the right laws at the states to deal with underage smoking, to deal with our various smoking policies. So we got involved because, as we mentioned in the Medicaid arena, we followed the money, and states will follow the money if the money is there.
I'm like Jerry. I was elected in 2002 as well, so we kind of we were the people after the tsunami flood subsided. We got to move into the neighborhood, and I think that's fair. Most states had, loaned their money out so they could balance state budgets at that point in time, which was a big boost, and deferred that problem off for a few more years. But there are significant enforcement obligations that still exist. And frankly, those overlap with yet another thing we talked about earlier, which is that the enforcement obligations ostensibly create a level playing field so that everybody has to follow the rules which were agreed to by those who participated in the settlement. In Wisconsin, we saw a lot of violations of those rules by off-brand cigarette manufacturers. We had issues in terms of their sale on tribal lands. We're a PL280 state, so we have a state jurisdiction over all tribal lands except the Menominee Reservation in Wisconsin. But so you had issues with cigarettes moving there. You had enforcement issues with youth smoking. You have enforcement issues with cigarette sales on the internet. There are a variety of things like that. But again, many of the states took the monies they received, used them for other purposes, and now those states are stuck with these enforcement obligations, but no money with which to do the enforcement. So that's probably kind of one of the best examples of kind of a wide variety of the topics we've discussed today when it comes to these sorts of actions.
We've gone past the 10 o'clock hour, so I'm going to ask one final question. And this is in the realm of theory and imagination. So imagine, if you would, that you're sitting before a group of brilliant Hill staffers. And imagine further that you're still the Attorney General of your state. What's the one thing that you would like those brilliant Hill staffers to know about the interplay of federal law and enforcement by your office?
We'll start with Jerry.
Just show us the money. I mean, bottom line, consider myself not an activist Attorney General, but AGs will move to where the money exists.
You could be Jerry Maguire.
Yeah.
When I agree with Jerry wholeheartedly, I mean, if there aren't resources available, it's not going to happen, or it's going to happen in a perfunctory way that doesn't have true meaning. If there are resources, frankly, it may happen. It may also be something where those resources are used in other fashions, where people are crafty and, shoehorn some other program they like better into those resources. But I think there's that issue. The other thing I would say as well is that I do think that making clear the nature of the relationship between state and federal agencies and trying to minimize the competition or of the two, if there are ways in which a piece of legislation can call for working together. I hate task forces. I refuse to call anything a task force or an exploration committee or a whatever, or a blue ribbon committee. I always figured that was a way to not make a decision and put it off for another day and then blame everybody else for whatever you have to do. But I do think that forcing bodies into the same room on a regular basis in order to talk about whatever the mission at hand is something that is useful. Because I think otherwise, when like joint enforcement authority is given and monies are given to a variety of agencies, be they state, federal, or a combination, that the individuals within a particular agency have that agency loyalty, and then when they're back home at their own agency, kind of discuss, the problems with an action and quickly blame it on someone else. So I think, the more you have family dinner, the more the family stays together. And I don't know, somebody once told me my experiences in raising 5 kids was more valuable to me than going to law school, and I sometimes think they're right. But I do think that putting everybody in the same room together is probably a good idea.
I guess as related to our topic here today, after spending some time looking at this and thinking more about it maybe than we've even done in the course, that you just need to have realistic expectations about what the Attorney General powers statutes you put in your federal laws are going to have, because based upon what I've seen so far, it hasn't done much. And I guess that means it's not harmful to put them in there, but I don't think you can expect too much in that regard when it comes to putting them in new statutes down the line. The other thing I'll say, and this is going to, I think you'll find this very odd coming from a person from the executive branch, but I've never run or been at an agency or a government entity where I didn't have all the money I needed to do the job that was mandated. And in fact, every place I've ever been, we end up at the end of the year with extra money. Now, I'm sure that's not the case now. I mean, I'm sure there's a lot of governments out there and entities due to the economy, but that also tells me that there are areas to do some cuts and to get some efficiency. So maybe you didn't ask about finances, but that's the one thing that struck me sort of every place I've been, is that if you needed the money to do your duty, you could pretty much find it. That doesn't mean you find the money to do a new federal mandate that's given to you that you don't have the money to do. I'm not suggesting that. I'm just suggesting that maybe it helps us prioritize these things, and maybe it does help us from being a little, not to be too activist. I mean, we all want to be activists. We wouldn't run for these jobs if we didn't. We do it in other areas. But the more money that's out there, the more mischief one can scare up. So,
Thank you. We're down to the last 10 minutes, and I'd like to take that time to see if there are questions from those attending the course. Any questions for either panel?
This is just, I guess, for all the former state attorneys general or Professor Raffety, I guess, opinions that we want to do. Probably the most frequent issue that has come up in Congress in the last couple of years on state attorney general empowerment kind of ties together the follow the money, the resources point, and the parents patriae standing under the Consumer Product Safety Act, and also some of the abuses of the tobacco suit. And that is whether or not state attorneys general should be subject to the same limitation that federal enforcement agencies are in enforcing federal law against entering contingent fee arrangements with outside trial lawyers to pursue the suits for money damages. And the Consumer Product Safety Act, and you say it's not been used, the original draft included money damages.
Yep.
And the belief on the, at least within Senator Cornyn's office, was that it was intended to create basically a workaround for the Class Action Fairness Act and other class action suits, and to create new consumer products class actions on the state level. And that if you allow full outsourcing to plaintiffs' firms, then it's sort of a dream for the attorneys general. There's no resources required. You can only win money damages, and it ties into one of Senator Cornyn's direct predecessor as state attorney general went to prison for abuse in the tobacco cases. There are allegations of pay to play in various states even now with state attorneys general. So I guess I'd just like to hear the panel's thoughts on whether or not the ability to outsource to plaintiffs' firms, which is not available to federal enforcers, should be available to state attorneys general.
they're asking me to speak first because this is a tough one. Really, I know it doesn't seem maybe as tough to some, but let me ask you this. You talk about outsourcing cases to plaintiffs' firms. What if you outsourced it to a defense firm? Would that make any difference? Or, I mean, are we looking at who it's outsourced to, or are we looking at what is outsourced?
Well, I think arguably the contingent fee arrangement does change the incentives in a way where there's no risk to the federal FISC for failure in a plaintiff's action if it's outsourced on a contingent basis. so to the extent that you're concerned about pay for play, where, and some of the worst law firms who do this, who make donations and bring these suits are from Texas, I believe. But to the extent you're concerned about pay for play, I think the contingent fee arrangement offers unique concerns because there's the state attorney general, his budget, his resources don't have any skin in the game, so to speak.
Right. Well, we did not do this when I was Attorney General. We did not outsource any plaintiff's cases, and we certainly didn't outsource some contingent. We did have to hire some outside counsel that could do some things we didn't do, which of course is different from what you're talking about, although right now we have a situation in New Mexico where a law firm from San Francisco was hired for one of the administrative agencies under a sole source provision under $50,000. It's now been extended, and they've paid $6.5 million on that particular contract, which I would argue is maybe more abusive even than a contingent situation would be. I can't say that today I would sit here and say there should never be a contingent case outsourced by an AG, because you might find one that you need to outsource. If you do it through a competitive bidding process, it's open, transparent, I think that makes a big difference. You give it to somebody who's one of your contributors, it's maybe I'm hope we're not arguing for public financing of things here, getting to that point so you can deal with people, but just because you participate in a political process, you don't want to be completely, taken out of the mix when it comes for representing the state. So I know what you're talking about. I know the issue very well. But I can't say that I would look at a blanket prohibition on that. And certainly we don't agree in pay for play, and we know people that have gone to jail for it. And maybe that's the remedy. I mean, maybe rather than completely throwing the baby out with the bathwater, that we just make sure that we catch the corrupt people, or we do our best to catch the corrupt people and go from there.
I would argue that this is a case where the conservatives have become the liberals and the liberals have become the conservatives. And I say that for one real reason, and that is that in a contingency fee case, and I don't always agree with them myself, and I do acknowledge the risk of pay for play, but I think they're bigger in other areas, that you essentially, as a state attorney general, make a decision that the state is going to assume no risk, but that the firm coming in is going to assume a risk. And some of these firms, lead paint in Rhode Island, I would predict that the chicken manure case in Tyson in Oklahoma, those firms are going to lose $50 to $100 million for taking on a case, and they're not going to get a dime. So if you want to talk about a marketplace deterrence for getting into those places, a true unfettered marketplace, I think contingency fee cases offer exactly that. Now that being said, you're surprised by that, isn't that? Yeah, okay, but the thing is that, that being said, I think that, I'll be very blunt about this. I mean, you go to the NAG meetings, you go to what is now DAGA and RAGA, which is like the Senate stuff and the House, DCCC or whatever you guys all call yourselves these days. I never get the acronyms right. But the reality is that there are a whole bunch of people there who have a lot of money and they dump it into the political system. And whether or not it's a state attorney general from a state where a ton of pharmaceutical companies raise. I was at a DAGA thing in Arkansas, and a particular AG had a fundraiser, and somebody who represents corporations was proud to say they'd raised over $300,000 in one night on a fundraiser, which mostly came from corporate funds and with AGs who have cases against those corporations. I think rather than spend all this time on the political left or right vilifying corporations or vilifying trial lawyers, we ought to be looking at what the real demon is here, which is there's a ton of money in this political process. And the real tragedy is when it starts affecting government institutions which deal with our courts and not with the legislative process, it becomes particularly onerous to all of us. So there's my 2 cents.
Yeah.
I am from Rosemont State.
As Attorney General, I work to make sure that we pass the PARSA legislation, which is the sunshine legislation that Texas has as well, to deal with outside counsel contingency cases. Politically, for any AG. Those are just tough decisions to make. I tell Democrat and Republican AGs that if you're considering taking a case by contingency, put it out to bid, make sure that it's just going to be political liability in the future should they win. Now, Peg's right. Sometimes they lose and they take the hit and you never hear anything about it. But if they win, you're going to see a headline and you're going to see your name in the headline with the trial firm to say that you gave them a sweetheart deal. Whether you did or didn't, you need to make sure that you have openness, let the sun shine in on the entire situation, and move forward if you think you need to.
Time for one more question. I'm going to take the opportunity then to remind you, please, please, please fill out our survey.
Yeah, I saw that.
These are of great use to us, and I guess following on the Jerry Maguire comment, help us to help you. By filling these out, we'll know what we're doing right, what we're not doing so well, and how we can improve the course in the future. So thank you very much for taking a moment to fill these out and return them to us. And thank you for being here. I hope you'll join me one more time in thanking the panel for being here. We will be having one of our regular Capitol Hill campus courses later this month on the 22nd, isn't that right? 25th, okay, with Dr. Bruce Yandel, who will be giving a quarterly economic update, and we hope that you'll come and join us for that. Those are always great courses. Thanks again.